Hey everyone, I'm Ryan Kalamaya.
And I'm Amy Goscha.
Welcome to the Divorce at Altitude, a podcast on Colorado family law.
Divorce is not easy. It really sucks. Trust me, I know. Besides being an experienced divorce attorney, I'm also a divorce client.
Whether you are someone considering divorce or a fellow family law attorney, listen in for weekly tips and insight into topics related to divorce, co-parenting, and separation in Colorado. Welcome to the Divorce at Altitude podcast. I'm Ryan Kalamaya, and I'm joined by Amy. Amy, how you doing?
Good. How are you? So today's the day after Valentine's Day. What do we have on the plate for today?
Well, we've got a really romantic topic. Day after Valentine's Day, we're talking about prenups. You excited?
Yeah, it's really a romantic topic for sure.
Well, I think not only is it a romantic topic, and people can certainly disagree about that, I don't think that there's any disagreement that the history and the litigation, and we've got a separate episode about attacking and defending premarital agreements because they do lend themselves to some juicy kind of gossip. You see celebrity, from the Dixie Chicks to Barry Bonds, the baseball player, to Dr. Dre. These prenups or Trump, you hear about these ironclad prenups and they are still challenged. They're fascinating. So the history of premarital agreements is interesting. The first documented premarital agreement comes from ancient Egypt approximately 3,000 years ago. The custom of dowry in Europe is also a form of prenup and dates back to at least the 9th century. The prenups or premarital agreements that we're talking about generally derive from Europe and specifically England, and they were targeted for second and third marriages because partners wanted to protect the financial interest of their children, specifically from their first, marriage. And there was a desire to spell out who got the castle if the lord predeceased the second or third wife. And that's still generally a motivating factor for premarital agreements today, except maybe not the castle and the lord part. But when you look at the 20th century and in the United States, there was a desire by wealthy families in the early 20th century to protect a daughter marrying a less affluent man. This was the predominant practice in the 1950s when divorce laws began to change across the U.S. And up until around 1970, premarital agreements that addressed issues relating to divorce were generally void against public policy, especially here in Colorado. And the idea was that they encouraged divorce. So, but before we get into that, and we could go on, Amy, and we'll talk about premarital agreements in depth, but can you tell us what exactly is a premarital agreement? And as we are recording here today, what are the requirements?
Sure. So in general, what a prenup is it's a contract that parties enter into prior to marriage where they set forth what the expectations are going to be during their marriage as far as running their finances, how to pay for things upon divorce or legal separation, how they're going to divide property, as well as if there's going to be any support to either soon to be ex-spouse. And also they can contract around death provisions, whether or not they're going to provide for each other, in a will, in a trust, if they're going to, just have the laws as they're set forth in the state of Colorado apply. So those are kind of, in general, the three areas that this agreement will cover. And as far as the key components to the Colorado premarital agreement, it has to be in writing and signed by both parties. Second, it also has to be voluntary, meaning that one party can't force the other party to contract to this. And you have to sign it, free and voluntary of your own will. The other key component is that each party needs to provide full and fair financial disclosures. And this is usually a schedule that's attached, or it is always a schedule, should be a schedule attached to the prenup that discloses what each party is bringing into the marriage regarding assets and debts. And you cannot limit or waive child support. So issues related to children, such as parenting time, decision-making, and child support for those children, you cannot contract around. And as well as the agreement may not violate public policy. So those are the main components in Colorado to have a valid prenup agreement.
So you can't say in 10 years that one party is going to get, $10,000 in child support a month, or that they're going to release their right to child support or lay out that you're going to have an equal parenting time schedule for the kids, right?
Yes, that is correct. And I think that also what would be interesting to talk about is you discussed, Ryan, the history of prenups. Let's talk a little bit about the trends that we're seeing now and why prenups are becoming more widely accepted, and actually a great thing to do before entering a marriage. So I don't know, I'll let you comment on this, but some of the trends that I'm seeing in my cases over the last few years are young couples are getting them. It's something that they want. It's something that a lot of times their parents are asking them to get if they come from, a family that has significant wealth. I also think that people that I counsel, they're more aware of the divorce rate. And they are just more, I guess, practical about, this marriage. Their hope is that the marriage will last for years, but it might not. And so they want an agreement that provides for longevity throughout their marriage. And if it doesn't work out, lays out a map for setting forth, what they can expect upon divorce or death. Do you have any comments, Ryan, or what are you seeing as far as trends related to prenup?
Yeah, I think that's right. Looking at, various articles and, my understanding or my observation is that generally younger people, they've seen their parents go through a divorce. I mean, you, Amy, you saw your parents go through a divorce, right?
Absolutely. Yes.
And so I think people are a little bit more realistic. There's always this tension between, well, you're not marrying me for my money versus, well, why are we signing an agreement if, we're going into this wedding planning and you're not planning on getting a divorce. And so there's always this tension between love and money. And I think a lot of people are a little bit more comfortable, younger people or people, for second or third marriages. That certainly is a trend. One thing I think is I've certainly thought about is that, we're recording this during COVID, during a pandemic. A lot of weddings were canceled in 2020 because of the safety precautions and the societal restrictions. And so they're getting kind of bumped up into 2021, 2022. They've seen all these statistics, all these articles about the divorce rate spiking. So, as much as we kind of talked about, well, there's going to be a rush to have divorces. What do you think of the kind of idea that we're going to see a rush of people wanting premarital agreements because there's going to be a cluster of weddings coming up in this summer for 2021 as things hopefully ease up from the pandemic?
Yes, absolutely. And I think also, one of the things that I'll talk about is I'll call it the signing ceremony. It's important that, that's done a lot of times in person. You don't have to do it in person, but we'll talk about best practices. So I think people, as the COVID restrictions ease up, I think they're more willing to do that in person. They're ready to get married and they are going to need to plan by completing their prenups. I know that a lot of clients that wanted to enter prenups, actually of mine, they put them on hold. So they're going to be ready to start moving forward with those coming up here.
And as much as we talk about young couples, I think that there's a general trend for people having kids later in life, and they're also getting married later in life. So they're coming to the marriage with more money. Reportedly, Kardashian and Kanye West, their wedding was delayed because they were negotiating their premarital agreement. Both of those people had significant assets coming into their marriage. And, now that it's on the rocks, it looks like that was probably time spent or time well spent. But would you agree that more people are coming to the marriage with things that they want to protect?
Yes, absolutely. And I think also you look at people who are getting, second, third marriages later in life. Their kids are grown. They have significant assets. They've lived 40, 50, 60 years of their lives and they want to protect those assets and they want to transfer their wealth to their children. And so you're seeing that as well. On a personal note, my mom got remarried 5 years ago and I advised her to get a prenup. And it was mainly because both her and her husband have children and they want their wealth to go to their children. So we're also seeing, that trend as well as people getting married later in life and having more coming into marriage.
Well, on our previous episode, we told the story about Eric Wolff's pending divorce and how he was uncertain about what was going to happen to his business. And if any of our listeners missed that story, they can go back to episode 1 or kalamaya.law/Eric-Wolff-divorce to read the full version. But as a reminder, he asked himself, how will we split our property? What about my business? Can I protect it? As we discussed earlier, Amy, Eric didn't think he'd be going through a divorce when he got married to Melanie. I never thought this would happen to me. But Amy, let's say that we could go back in time and Eric called you about drafting a premarital agreement for him. You can't address what happens with the kids or child support. We covered that previously. But what are the considerations for you representing Eric in a premarital agreement before his marriage to Melanie?
Absolutely. So my number one goal is to protect my client's assets and income. And how I do that is I need to make sure that I've provided full and fair disclosure to the other party as well as to their attorney. You know, if I'm representing the person who has more wealth, their financial picture might be a little more complicated. So I need to make sure that I'm providing the requisite information regarding trust, regarding businesses. You know, we'll get further into the disclosure piece. Another thing is I need to make sure that the agreement is a well-negotiated agreement that is somewhat equitable for the lower earning, soon to be spouse. I don't want the lower earning spouse to come in and try to attack this agreement down the road, as well as I want to make sure that both parties are, represented by competent counsel. So, those are kind of the three main areas that I focus on when representing the wealthier client.
Now, you, in your kind of requirements for a valid premarital agreement in Colorado, you didn't mention counsel. We'll get into that a little bit more, but can you just give us the audience a little bit of a preview into the role of counsel for both parties in a premarital agreement negotiation?
Absolutely. So I think that where having counsel is super important is that when you're looking at full and fair disclosure, you have an attorney who can explain what that means, what the agreement means, what financial information should be exchanged back and forth. Also, it's very important when looking at the agreement for negotiation purposes. It should be a negotiated agreement, not just one draft should be done. There should be negotiation on both sides, which an attorney can help with, as well as the sophistication of certain clients. Some clients are very highly sophisticated and understand financial distribution of, what could happen upon divorce. But you really need someone who can counsel the client on what happens in divorce if you had this agreement, and what happens in divorce if you don't have this agreement. What happens in death if you have this agreement? What happens in death when you don't have that agreement? So that's really where the role of the attorney comes in.
And when you are talking with a client that has more money than the other person, what about walking away from the agreement? How does that play into your advice for clients?
As far as walking away from the agreement, I think that my client, I need to make sure that they have points that they can negotiate. And if it's not something that they're willing to negotiate, then, they possibly might need to walk away from the marriage. I know that sounds kind of harsh, but, it's the reality is that if they want their soon-to-be spouse to, enter an agreement, they have to be willing to provide something that is somewhat equitable upon divorce and upon death.
Let's switch gears, Amy, and focus on Melanie. So if we could go back in time and assume that Melanie doesn't have as much money as Eric when they get married, what are the practical considerations for a Colorado attorney that represents Melanie in negotiating premarital agreement with Eric?
Sure. So when I'm representing the party with less wealth, I'm really looking to negotiate a somewhat equitable agreement to make sure that they're protected in various circumstances. A lot of people that come to me and that I'm representing are in the, I'm getting married, I'm super happy, not thinking about well, what is their life going to be like if they're giving up their job to be a stay-at-home parent? What happens 10 years down the road if you end up getting divorced? Like, are you going to have a house that you can, live in to provide, a standard of living for your children? So it's really about protecting the less wealthy spouse in certain scenarios to make sure there's somewhat a fairness in the agreement. And also just talking to the client about, there are circumstances that they need to be prepared to walk away. There have been, even recently, I had a client who, the other side would not agree. Essentially, it was a waiver of everything, a waiver of spousal maintenance, a waiver of any kind of property whatsoever, no agreements to to convert property into marital property. So my advice to her was, this is probably something that you need to walk away from.
And I think part of your role, would you agree, is when you're dealing with maybe a less wealthy client, explaining to them what would happen if they were to get married and there was no agreement, like what the default would be under Colorado law, and how this contract is changing that default law.
Yes, exactly. And that's one of the things when we get into best practices that I do is I send every client, including the client that earns less, here's what the law is in Colorado on dissolution of marriage without an agreement, and here's what can happen with the agreement. And a lot of times I'll send the client a letter, very detailed, that says, okay, so here's the Colorado law. Here's what this agreement is doing that's different than what you would get just under Colorado law.
Now, you mentioned kind of what you do, and we have another episode coming in terms of attacking and defending. And in part, your best practices are guided by some of the litigation that we've dealt with in challenging or defending premarital agreements, right?
Correct. Yes. And I think I'll just touch on some of those other best practices. I was talking about the law packet that I send to everyone. What also is important is to have checklists. We have checklists regarding what financial disclosure documents we need to get from our client, what financial disclosure documents we need to get from the opposing counsel. We send the letter to our client about what does it mean to have full and fair disclosure? I schedule a meeting to go over the financial disclosures of the other party. I schedule a meeting to go over the draft of the premarital agreement and what it means and suggested revisions to it. Also, if a client accepts terms against what I'm advising, I provide a written letter to the client and I make them sign it. So they are acknowledging, that they're deciding to move forward against my advice, and that they understand, what my advice is to them.
Now, these checklists, we use practice management software and we have kind of a series of tasks. Why do you use a checklist? Like, why not just go off of memory?
Because, we're human and humans are fallible to error. And so we want to make sure that in every case that we're handling, we're doing every single step. So checklists are imperative to make sure that nothing is missed.
Yeah, my wife, her father, my father-in-law is a pilot. And, I've gone up and flown with him and, he's been doing it for 30, 40, years, but he's got a checklist. And it's like pilots, like what we say within our firm, there's a reason that pilots have a checklist, and that's if you don't check every single box, you could die. And for us, it may not be, living and dying, but it certainly is a factor in the malpractice, claim. Can you talk a little bit about, malpractice claims and other attorneys and selecting an attorney for the other side and independent counsel? Because those are certainly issues that many people, I think, are surprised when they hear us talk about, malpractice. Why do we even mention that?
We mention that because I think a lot of times, and this even dovetails into estate planning. In Colorado, we have forms. And so I think a lot of general practitioners might say, well, I can just, this is an easy form. I can fill this form out, and Ryan, you and I have been on the other side of that, where those prenups are contested in court. And so, that's a huge malpractice issue. And so it is important when you're doing these types of agreements that you know how to draft them, the ins and outs of them and what can be litigated. An example would be the choice of law provision. There's just certain things that you need to make sure are clear in the agreement. and there's certain provisions that are highly litigated if they're not clear. So it is important that you do know exactly what you're doing when you're drafting these agreements.
Yeah, I mean, I think it's telling that there are a number of very respected divorce lawyers in Colorado that will not do premarital agreements drafting. And it's because there was there's been several well-known claims against very good attorneys that didn't do exactly everything that they needed to do. And there was a significant claim against them. And so a lot of people in the Colorado divorce lawyer world decided the cost benefit just wasn't worth it because the fees related to it just didn't justify the amount of exposure. Because usually when you're dealing with a premarital agreement, it means that there's someone that is looking to protect a fair amount of money. And if it doesn't go right, and Amy, you and I have seen this where people were just kind of shooting from the hip, and there was a significant malpractice claim against, these lawyers that, they meant well. They just were unfamiliar. They just thought it was just a normal contractual kind of negotiation.
Yeah. And I still see that, there was an agreement recently where I received the draft and the financial disclosure. And on the financial disclosure, it said essentially a trust interest. And so I went back to opposing counsel and said, I really need a summary of what this trust is, what it owns, who the beneficiaries are, who the trustee is, what type of, power does the trustee have to essentially the power of appointment. It just gets so complicated. And come to find out, the trust was worth the corpus just the assets in the corpus of the trust were $15 to $20 million.
So Amy, given your experience, do you pick the other lawyer for the other side, or how does that work, and who pays for the other attorney?
Best case scenario, no, I do not pick the attorney for the other side. I have had circumstances where the other party does not know of any lawyers. And so, I will say, here's a list of possible lawyers, but it's your choice. You need to go interview them. Best case scenario, I want the other party to pick their own lawyer. There are circumstances where the wealthier client will pay the attorney's fees for the other party. However, that's, the best case scenario is they pay their own attorney's fees.
Yeah, and we'll get into this with kind of challenging, but the kind of rationale, just to give a preview, is that there's been claims that the other party their attorney was a straw man, and that it was just a rubber stamp deal, and they challenged the fact that they had a particular attorney, or that that they couldn't afford an attorney. I think it's a fair observation that, generally speaking, if there are two attorneys representing two people, it is very difficult to set aside and challenge that. Not necessarily challenge it, but that, to successfully challenge that. What about joint representation? Hey, Amy, can you represent the husband and wife in a negotiation on their one premarital agreement?
No, that's completely not okay and not legal. So can't jointly represent people like you do in estate planning.
Yeah. And I think there's a case I'm aware of in West Virginia in which that was one of the reasons that the court set aside, was because the lawyer purported to represent both the husband and wife, and the West Virginia court said, no, that was not how it should have been. So let's talk about financial disclosures. What goes into a proper financial disclosure, and why do you do that?
So what goes into a proper financial disclosure is essentially, in my agreements, I have an Excel spreadsheet that lists the description of the asset, the estimated value of the asset, how I came to that estimate, or how my client came to that estimate. I back up, I paper it with, a recent statement, possibly, if it's the value of a house, maybe there's a recent appraisal. If I'm dealing, I want to specifically talk about, trusts. So with trusts, I attach a separate addendum that's separate from the financial disclosure. And it's essentially a description, a summary of the trust. I put on it the name of the trust, the owner of the trust, who the trustee is it revocable? Is it irrevocable? Who the beneficiaries are, the assets in the corpus of the trust, that, identifying them, what the value is upon distribution, what my client would get essentially under different scenarios. And also, what power does the trustee have to make distributions? So I don't necessarily, in every scenario, ask for a copy of the trust. Sometimes I do, but I normally see that if you provide a very detailed description of the trust, what's in the trust and what the client is going to get and the value of that is sufficient.
So when you're going through this, what kind of problems are you anticipating?
So I'm definitely anticipating future inheritance, what to disclose, what not to disclose. If there's business assets, has there been a recent appraisal? What loans does the business have? Is there, key man insurance? Is there an application? Is there a divorce of another owner? I'm also looking at hard to value assets, and how do I disclose that? An example of that might be like a timeshare. Those are hard to value. So what am I going to do? What am I going to disclose? And how are we going to value that? Expected changes, whether or not to disclose those or not. And also, more is better. I guess the main message is that more disclosure is better than less, because an agreement can be invalidated for failure to disclose.
Yeah, and I think that the law is catching up with these best practices. Before 2013, when the Colorado legislature updated the law on what was necessary for premarital agreement, it used to be that you didn't have to disclose, necessarily income or the values for a particular asset. And now we've got to disclose, or in order for there to be a valid agreement, you've got to disclose income and put an actual number amount there for a particular asset.
Exactly. And I mean, it's just my practice where I always disclose at least the last 3 years of tax returns, the most recent, bank statements, mortgage statements. And then even on the asset disclosure, I list what is the adjusted gross income of the party for the last 3 years.
All right. Now, negotiation. So you get your disclosures. What happens when you start negotiating? What things are you mindful of?
So if I'm reviewing a prenup that another attorney has drafted, it needs, for it to be valid, it needs to be a negotiated agreement. So for instance, if I'm representing the party that has less money and I receive an agreement that essentially waives every single right, I am looking to negotiate that my client gets some kind of lump sum money payout upon divorce, or is getting some type of spousal alimony, depending on how many years they're married, that, my client is getting a certain percentage of income, or that there's agreements to essentially convert property, separate property to marital property, or, a cash payout. So those are the types of things that I'm looking for. And usually we have agreement, drafts of the agreement that go back and forth. And it's a best practice to save every single one of those versions. The more versions that go back and forth, to prove that it was more of a negotiated agreement.
Right. And the idea is that because there's, these examples from other cases in which, someone is presented with sign on the dotted line, this is a take it or leave it, it lends itself to a claim of duress or, involuntary signing or coercion. And so is that why you're so keen on an actual negotiation?
Yeah, the essence of negotiation is that actual negotiation, there has to be bargaining between parties, and that can be shown through the various drafts that are going back and forth. And so that shows and proves the voluntariness of each party being able to enter into the agreement, not under duress.
Okay. So from your perspective, when you're negotiating the terms, what's the starting point?
I mean, the starting point is always title controls. So we look at that, and we look at how to transfer title. We work out carve outs. I was explaining how to convert maybe a separate residence that's titled in the higher earner's name or the wealthier spouse's name that gets transferred into, joint title that then converts it to marital property. You're also looking at essentially the parties share in the fruits of their labor and keep premarital and inherital gifts and assets separate, that whatever is purchased during or acquired during the marriage, titling does matter, because usually the prenup is set up where if it's a separate asset in someone's name, that remains separate. And if it's jointly titled, that might be subject to division, equally upon a dissolution of marriage.
Yeah. And one of the most common questions that we get, which we'll address in a separate episode, is does title matter? And generally, in a normal divorce, it generally doesn't matter if it's acquired. If something was acquired after the marriage, it's presumed to be marital property. But the premarital agreement, when you say title controls, are you suggesting that most of the time you're stating in the premarital agreement that you're changing that presumption under the law, and instead you're defining property as, that title really does control?
Correct. And that's very different than dissolution of marriage law in Colorado.
With that in mind, Amy, what specific terms would you be looking at in a Colorado premarital agreement between Melanie and Eric if you represent Melanie? In our story, Eric wonders what's going to happen to the house. It's one of the most common questions that we get from clients beginning a divorce. How could that issue play out with Eric and Melanie in negotiating a premarital agreement?
I think that especially if I'm representing the spouse who's not as affluent, if they're going to have kids, I want to make sure that there's a house that upon divorce that the client will have in order to have a certain standard of living for the children. So it's not very different than when the children are with the more affluent spouse. So that can include paying off a mortgage or converting, a separate property, real estate to marital property. Also survivor benefits. So we haven't really talked a lot about the death benefits, but to make sure that I'm making the wealthier spouse agree to leave X amount to the less wealthy spouse. There can also be, life insurance policy requirement to be taken out. So those are the types of things that I'm looking at to negotiate for the spouse that's not as wealthy.
When I mentioned the history of premarital agreements, I mentioned, children from, a first marriage. How does the kind of death provisions and in Colorado relate to what oftentimes are the desires in a premarital agreement with respect to the spouse and children?
So a lot of times, like if from a first marriage, if you have children from a first marriage, you're going to want your essentially assets to go to them. However, in Colorado, depending on how long you're married, the second spouse, has certain benefits. It's called an elective share. And so under Colorado law, depending on if you're married X number of years, they can get up to 50% of, your estate upon death. And so it's really important to understand what are all the dynamics and also to set forth within a premarital agreement, what your client wants upon death. I think a best practice a lot of times is to waive the rights and to say that the estate planning documents control. However, to put some type of provision in there that says, especially if you're representing the lower earning spouse, that the higher earning spouse has to leave X amount, in estate planning, documents for them.
Yeah. And this is something we somewhat touch on in separation agreements, actually during a divorce, when two people that have children, they can provide for their children and have an agreement, which, we'll touch on at some point in the future. Why don't you talk about a little bit on waiver of spousal maintenance and some other waivers that normally appear in a premarital agreement?
Yeah. So under Colorado law, in Colorado, if you're married 3 years, you can qualify for spousal maintenance. We have an advisory guideline that goes up to a certain amount. And so a lot of the premarital agreements, you'll see a waiver of the right to spousal maintenance upon dissolution of marriage or legal separation. And what I'm looking for is if I'm representing the spouse who earns more money, I'm looking for that waiver for the lower earning spouse to waive their right to spousal maintenance. The caveat, though, is that, and I know we'll be talking about this in another subsequent episode, is that the courts do look at this waiver at the time of enforcement. So it's not ironclad. A lot of times when I'm negotiating spousal maintenance and prenup agreements, I'm first providing the client with what does it look like under Colorado law under certain scenarios? What would the spousal maintenance look like? As well as, if I'm negotiating it, either I'm going to put a schedule in there about percentage of income and define what income is and tie that to the number of years that the parties are married, or I'm going to negotiate some type of property payout, and both parties will do a mutual waiver of spousal maintenance.
And what about waiver of attorney's fees?
So waiver of attorney's fees as well. You usually see a provision that says the prevailing party, meaning that each party has to pay for their own attorney's fees, upon a dissolution of marriage or legal separation. And if either party tries to essentially invalidate the prenup, that the party who loses has to pay each party's attorney's fees. And the caveat with that, again, is that this waiver can be looked at by the court at time of enforcement.
And choice of law, what does choice of law mean? And why is that something that you address with premarital agreements?
Yeah, so I carved out here choice of law provisions because these are provisions that can complicate litigation or can be litigated. So every prenup usually does have a provision in that says what laws apply. So if you're getting married in Colorado, I'm going to have a choice of law provision that says that Colorado law applies. And it gets complicated because if parties move, they might have a prenup that says that Colorado law applies. So you can see that, that can get kind of more complicated. And the whole point is to establish a nexus in recitals with the state of the law. And I think it's important to also include that the agreement is enforced as the law changes. In 2018 in Colorado, we had where spousal maintenance was taxable to the party that received it and tax deductible to the party paying it. That changed in 2018 where it was not tax deductible or taxable as income. And so it's important that these agreements, they have to be able to be interpreted clearly throughout the years. So it's important that your choice of law provision is specific. And it is important to be aware that choice of law may not be upheld on fundamental public policy grounds.
Okay, so you got the agreement, it's been negotiated, we're all good. How do you get it signed and what are things you're looking out for?
Sure. So the last part, we have a negotiated agreement. Everyone agrees on the terms. Now it's time to sign the agreement. My general rule is I don't have parties sign agreements less than 30 days before the wedding date. At the signing, I prefer for each party's counsel to be present. It's also really important that each party initials each page and that they're bound together. And it's important to also include the financial disclosures exhibit to the prenup to make sure that, it's present. Each party has reviewed it, understands it. I do 4 original copies or 4 original documents. So one goes to each attorney, one goes to each party. And recently, in recent years, I started filming these. I do think it's a best practice to film the signing so it's very clear as to what questions were asked, what pages were present. And so I think, that's probably the best way to wrap up, signing the agreement, to get it done.
Again, we've kind of been previewing or foreshadowing, another segment on attacking and defending, but most of these little highlights that you have about initialing pages, having originals go to multiple parties and filming, they're the result of learning from other people that have not done those and have had agreements successfully challenged. And, Amy, you laid out a lot of these kind of unique things regarding the signing of an agreement. Why do you have these particularities in your checklist of things to do for premarital agreements?
Because it's all things that you, Ryan, and I have seen that people have done wrong, right? And so it's something that we want to make sure is done in every single agreement, and had mentioned that, even some highly sophisticated divorce attorneys won't do premarital agreements, and they're kind of an area for, I guess, vulnerability for malpractice. So you have to do every single one of these best practices to make sure that, it's a negotiated, financially disclosed agreement that's going to be enforceable, and your client's not going to come back and point the finger at you, that you did it wrong.
Well, Amy, I think that's a good place to end. And, if anyone has any questions about premarital agreements, whether they be a potential client or another attorney, where should they send you an email? Should they give you a call? What's your preference?
Yeah, either is fine. So they can call me on my direct line, which is 970-306-6178, or you can email me at Amy, AMY, at Kalamaya, KALAMAYA.law.
Well, thanks.
Thanks.
Hey everyone, this is Ryan again. Thank you for joining us on Divorce at Altitude. If you found our tips, insight, or discussion helpful, please tell a friend about this podcast. For show notes, additional resources, or links mentioned on today's episode, visit divorceataltitude.com. Follow us on Apple Podcasts, Spotify, or wherever you listen in. Many of our episodes are also posted on YouTube. You can also find Amy and me at kalamaya.law or 970-315-2365. That's KALAMAYA.law.